Hey, what's up? Okay, I think I'm all set now. Right. It's okay. I'm good. Okay, how's everyone doing? Let's see. Just give it a few more minutes as people show up. But while I'm waiting for people to show up, I wanted to address something real quick. So I don't know if anyone listened to Todd. I'm sure everyone listened to Todd Chrisley's podcast from yesterday. There was one part, though, in the podcast where Todd had misspoke. And I wanted to just clarify that. I think for the most part, like many of the people watching the live stream kind of know the facts of this. Especially if you follow me at all on Twitter, because it seems like I'm always arguing on behalf of myself there when it comes to this. So, but I just want to clarify, though, when he spoke of the police officer in his live stream or in his podcast, I apologize, yesterday, he misspoke. Like I said, it wasn't the police officer that Katie accused. Katie accused another person, someone she had gone to school with. What she accused the police officer of doing was refusing to investigate her case. She accused him of calling her a liar, of saying that there's no way that the person she accused of doing that could have been guilty or could have participated in anything like that because he came from such a good, prestigious family. She says the police officer berated her for 2 hours, interrogated her to the point of tears, kept calling her a liar, said that she was a jealous, jilted ex-girlfriend or whatever, and she was just mad because he didn't leave a number and whatnot. So that's what she accused the police officer of doing, which if you follow me at all, then you know my involvement in helping that get disproven, or rather helping that get debunked, because it was never proven. So I'm not going to go into detail about that in this live stream, though, because it's been talked about an awful lot. But I'm happy to talk about it at some point in the future if people want. But for today, I wanted to cover the lawsuits. So there's that. Okay, I feel like this officer has just got enough. I think that she's caused him enough damage, and I don't want to see him have to face any additional damage, as a result. And I know that Todd Chrisley meant nothing but, just he's got so much shit coming at him and everything about Katie. I mean, just think about, imagine being someone who just joined the subreddit for the first time, and you tried to learn about Katie. It'd be like, whoa, like you might think that going to school for a law degree might be easier. So I get it. I do get it. I'm just doing my part here. That's all. So let me check out chat here. Hey guys. All right. There's a lot of people here I haven't said hi to. I went right into talking. You pay $2.13 a month in call dues, and here I sit waiting. I was almost on time today. I was only like 2 minutes late. I'm actually a little proud of myself. So I thought to get into things, we would first just go right into reading the new filings, and then we can check out Todd's podcast. He talks about her quite a bit throughout the entire podcast, not all in one chunk, but a little bit sporadic throughout a good portion of the middle of it. So just looking to see so again, as always, if anyone has any questions that they want to ask me or anything that they want to tell me, just tag me in the chat so I can see it, because I'll go back and scroll back and look for the orange. If I don't see the orange, then I'm not going to stop, because when I'm reading these things, it's hard for me to look at both screens. So, all right. So let me share screen over here. God, why is this so bright? It's going to be so bright. All right. So this is the first filing that was listed. This was filed on April 11th. And this is, now again, I want to just point out, I am not a legal expert. I am not a law professional. I've never been a student of law. All I'm going to do is read this. I'm not going to try to explain them or state it for certainty what they are or are not. So this looks like it was filed by the plaintiffs, so by Todd Chrisley side. And it says plaintiff's notice of motion and motion to compel discovery. Now, what I do understand about compelled discovery is that they're in the discovery phase, and Todd Chrisley's side is trying to get their discovery out of Katie, and Katie is not cooperating. So this is a motion to pretty much get her to cooperate. And it says 2 defendants. Oh, shoot. Ah, fuck. Okay. I'm going to have to go through and check these again. Let me just make sure. Where is, okay. Turn that off for a moment. Is that the only place? Oh, okay. I'll call. It was just the lawyer's address. Okay, shoot. I thought it was Katie's address for a second. I was like, no, it's not though. Double check. I was gonna say I didn't think that I saw her address on here anywhere. Yeah, we're good. Okay. I'm gonna go back to sharing it. I just saw like the zip code there and just like, anyways, 2 defendants without a crystal ball and Catherine Mansky Paulson by and through their counsel of record, Graham Martin. Please take notice that plaintiff will move the court for an order granting his motion to compel discovery on July 20th, 2022 at 1:30 p.m. before the Honorable Catherine McPherson, unless it can be resolved by an informal conference pursuant to Minnesota Rule of General Practice. Motion. Plaintiff's motion is made pursuant to Minnesota Rule. I'm not reading the statutes or whatever. Response to plaintiff's interrogatory and failed to timely produce relevant and responsive documents. Plaintiff thus has caused to move the court for an order compelling defendants to supplement their interrogatory response and complete their outstanding and overdue responses to plaintiff's request for production. So this, yeah, they're just petitioning the court to compel that. Let's see. It's only 4 pages. I already checked these, but now I'm just double checking because they made me a little nervous there. I really thought I showed her address for a moment. I'm glad I was wrong. Okay, so now the second filing. It looks like there's 5 of them actually. I don't know, like they weren't all big filings, so I know that much. So this is the second one. As soon as it loads. Okay, and this was also filed on April 11th. Looks like this one was probably filed right along with the motion to compel. This is actually, I think, it just elaborating that. So it says, Dear Judge McPherson, Plaintiff Michael Todd Chrisley writes pursuant to Minnesota Rule, yada, yada, yada. Her refusal to respond. Okay, we got that. Under the parties' joint discovery plan, which has not yet been approved by the court or formalized into a schedule or scheduling order, the parties are to complete fact discovery by July 29th, 2022. With an eye to meeting that deadline, plaintiff served his first consolidated discovery request on December 10th, 2021. Defendants missed the deadline to respond, and when questioned, stated that they did not believe discovery should proceed in this case until the court ruled on their motion to dismiss. Yes, she's saying that, or they're saying that they don't feel like they really have to participate in this court, all this court nonsense, because they think the case is just going to be dismissed. So why bother? After plaintiff explained that there was no stay of discovery in this case, defendants served incomplete and evasive discovery responses on plaintiff on January 17th, 2022, beyond the 30-day deadline imposed by the Minnesota Rules of Civil Procedure, and have subsequently refused to supplement those responses. In the 3 months since then, defendants have produced only a small number of documents, most of which are images of publicly available materials, and some of which are not clearly responsive to any of plaintiff's discovery requests. Defendant's failure to fully and timely respond to plaintiff's discovery may require plaintiff's filing of a motion to compel. However, the first available date on which the motion may be heard by the court is July 20th, 2022, which is roughly 1 week prior to the proposed close of fact discovery. Accordingly, plaintiffs request that the court schedule an informal telephone conference at its earliest convenience and set a briefing schedule to resolve these discovery issues, which are set forth in more detail below. So they go into more detail about what the issues are. And it starts with saying, defendant's failure to respond to number 3. As context for this request, it's important. As context for this request, it's important that the court understands the factual genesis of the case. Plaintiff Todd Chrisley is a real estate investor and star. Okay, we already know that. Defendant is internet personality. Through her company, Defendant Without a Crystal Ball, LLC, she monetizes her social media presence on YouTube, Twitter, Instagram, and Facebook. Ms. Paulson publicly claims to be a close friend of Mr. Chrisley's daughter, Lindsie Chrisley, who appeared on Chrisley Knows Best for several seasons until the network declined to include her in future seasons of the show, or of the program. At that point, Lindsie Chrisley became estranged from her father and the rest of her family and lashed out at them in the media. Lindsie Chrisley appeared on the daytime talk show Dr. Phil on October 17, 2019. She recounted a meeting with Mr. Chrisley, during which Mr. Chrisley allegedly told her that Chase Chrisley, her half-brother, had obtained a sex tape featuring her and a man other than her then husband for $5,000. Lindsie Chrisley agreed when asked by Dr. Phil that she viewed this as a quote-unquote veiled threat related to her cooperation with law enforcement in its investigation of Mr. Chrisley and the rest of the family. This account of the meeting was inaccurate, and there was no such threat. Ms. Paulson spent 2 years following this interview spreading, embroidering, and expanding upon the defamatory falsehood that Mr. Chrisley attempted to extort his daughter by threatening to release a sex tape featuring her if she refused to lie to authorities investigating the Chrisley family. In particular, 2 days after Lindsie Chrisley appeared on Dr. Phil, Ms. Paulson published a YouTube video falsely claiming that, quote unquote, somebody anonymously from the Chrisley Knows Best crew actually reached out to me to let me know they watched Lindsie Chrisley's interview on Dr. Phil, and they said, I believe her. I'm not even lying. Plaintiff's interrogatory number 3 focused specifically on Ms. Paulson's claimed conversation with this anonymous Chrisley Knows Best crew member. It requested that she, quote, identify any member of the Chrisley Knows Best television production crew with whom you have communicated, including the nature, substance, and date of the communication, unquote. Plaintiff made this request because he alleges that Ms. Paulson fabricated this call to bolster the credibility of her false allegations and boost her perceived reputation as a person with inside knowledge. The requested information is particularly critical to plaintiff's case because, as a public figure, Mr. Chrisley must show that Ms. Paulson made the defamatory statements at issue with actual malice. The circumstances of Ms. Paulson's supposed call with a Chrisley Knows Best crew member go directly to her actual malice because, quote, a statement may have been made with actual malice if it is fabricated by the defendant, is the product of her imagination, is based wholly on an unverified anonymous telephone call, or if the publisher's allegations are so inherently improbable that only a reckless man would have put them in circulation. That's good. Ms. Paulson largely refused to provide the requested information, stating, objection, calls for information protected. Y'all. Sorry, I had to channel Emily there. Okay, get this. I'm going to say this again. I'm going to start over again for this. Ms. Paulson largely refused to provide the requested information, stating, quote, objection, calls for information protected by the journalist's privilege outlined in Minnesota statute 595.021-025. She's saying no. That's information protected by the journalist by a journalist privilege in the state of Minnesota. That's why she's saying no. Okay. All right, moving on from that one. Subject to that objection, defendants never received the name of the person with whom they were in contact. Ms. Paulson's response frustrated Mr. Chrisley's effort to obtain the discovery necessary to demonstrate that Ms. Paulson did not receive the claimed call from a member of the Chrisley Knows Best crew. In particular, it did not include any information concerning the circumstances or substance of the call or any detail as to Ms. Paulson's efforts to confirm that this individual was a Chrisley Knows Best crew member. And, that's what amazes me. Like, she uses the phrase anonymous source a lot. But the thing is, though, is that the anonymous source isn't supposed to be anonymous to the reporter. It's supposed to be anonymous to the public reading the story. The reporter is still supposed to verify who this source is, what their connection is with the subject matter or the person in question, and whether or not the information they are sharing is something that they truly would have witnessed or known or have some sort of inside knowledge on, and whether or not they did, in fact, witness or whatever the claim may be. But it's still the reporter's responsibility to verify both the source, who they are, if they play a role in the person's life or the situation's life to speak on such matters, and also if the matters in which they're speaking on are as factually known as possible. So if she's done neither of these things, then yeah, that's negligent. And again, this is kind of why people go to school for things like journalism, because then they learn shit like that. Just saying. Oh, Tina, that's okay. I have it all. I have it all. Okay. I'll send you the link. Don't worry about that. It's all good. In fact, give me a second. I'll send it to you while I'm on stream here. So give me a couple minutes. I'll send it to you. I want to go through. I know I have it all though. It's all put together still and everything. I think I put one other thing in there that I might just have to remove. That's all. So going on. In subsequent correspondence, Mr. Chrisley's counsel explained in detail why the privilege defendants invoke does not apply and requested that defendants supplement their response. Defendants refused. Mr. Chrisley's counsel then responded by email and requested to meet and confer. Plaintiff did not receive a response to that email. Without receiving a complete answer from Ms. Paulson on interrogatory number 3, Mr. Chrisley's efforts to prove that Ms. Paulson acted with actual malice will be significantly inhibited, and Mr. Chrisley can only assume that she will respond similarly to any deposition questions. Thus, Ms. Paulson must be compelled to supplement this response. Defendants' failure to produce documents. Defendants represented in their correspondence dated March 11, 2022, that they continue to, quote, work on the production of documents requested by plaintiff in December of 21. But another month has passed, and defendants still have not produced a single additional document beyond their facially deficient initial production. By plaintiff's count, the grand sum of defendant's production consists of approximately 60 files, meaning like 5 videos, MP4s, 35 pictures, 7 screen captures, and 3 documents. Defendant's production does not include any documents responsive to 6 of the 10 requests for production served by plaintiff. Essentially, every request that required Ms. Paulson to provide non-public information. Yeah, so basically, like there were like 10 requests of information. She fulfilled 6 of them, and the 6 that she filled was all publicly found information to begin with. On March 15th, plaintiff requested that defendants meet and confer as to the status of and timing of defendants' ongoing document production, given that more than halfway through the discovery period contemplated by the parties' proposed scheduling order, defendants had produced virtually nothing. But defendants ignored this request too and have continued to withhold documents. Because of defendants' obstruction of the discovery process, plaintiff has no recourse but to request the aid of the court. Based on the, okay, so there's that. Now the next filing, oh my God. He's trying to call the dog in the other room. Let's see. Huh. Okay. This one I hadn't even looked at yet. I forgot about that one. I thought that there was only 4. So this is the third new filing. Okay, so and this was filed on April 12th. So 2 days ago, and the day after the filings we just read were filed. And this is from Katie's attorney. And this, okay. And this is to the judge. So it's to Honorable Catherine McPherson, Wright County District Court, regarding request to reschedule hearing and defendant's motion to dismiss. Dear Judge McPherson, after being served with the plaintiff's summons and complaint in this matter on October 18, 21, the defendants in this matter responded with a motion to dismiss under Rule 12 of the Minnesota Rules of Civil Procedure. Initially, the hearing on that motion was scheduled for January and subsequently moved out to April. The motion is currently scheduled to be heard on April 27th at 2. The plaintiff currently has scheduled a federal criminal trial starting on May 16th. CUSA v. Chrisley, whatever. While that case regards charges of tax evasion, a number of the tangential, I can't freaking think of it. I can't even see either. I can't find my glasses. Issues regarding the witnesses, including Mr. Chrisley's daughter, Lindsie, and her interactions with various tax authorities regarding her father, regard news items forming the basis of the bulk of Mr. Chrisley's causes of action against Ms. Paulson in the case before this court currently. So that sounds like to me what her side is alleging is that they want to wait until after the criminal trial of the tax evasion because they believe that throughout the process of that trial, information that she's claiming exists of Lindsay's involvement in the information being shared or whatever regarding the defamation claims, she thinks that that's going to come out in the criminal trial and therefore help her case here. Of course, you bear in mind that this was conceived, typed, and submitted before Lindsie Chrisley's Instagram post from yesterday. Just bear that in mind. At least I think that was yesterday. Because witness testimony in the federal courts and jury's findings of fact in the criminal case may bear on issues relevant to this proceeding, Ms. Paulson respectfully requests this court's leave to reschedule the hearing on her motion to dismiss until after the conclusion of the trial in the criminal case, so that any relevant findings of fact may be considered by the parties and the courts in this matter. And that's pretty much the end of it. Please let me know if you have any questions, yada, yada, yada. Okay. So that was the third filing. Fourth new filing, is this the long one? I think this is the long one. Yeah, this is the long one. Let me just double check for address again. I don't think that they would put it in this one. Just I think the initial one would have her address. Oh, that's gonna be interesting. I haven't read all the points of discussion here. Page am I on? What am I doing? I can just look this up real quick. Okay, it's not in there then. Okay. So here's the big filing. I'm going to check chat before I start reading. Let me just get it up here and ready to go. Okay. So let me check the chat here real quick. All right. I guess it's, oh wait. What, so I take it that this not a class action lawsuit then? What happened to that? I don't know what happened to that. I really didn't have much information or knowledge about that anyways. I know that there was something that Todd Chrisley spoke that he would wanted to do, or he was, I think, trying or hoping to do. Beyond that, I know nothing more about it. So he did say though, or there was reference or talk about basically Katie's not done being served with lawsuits. I don't think that these will be moved into a class action lawsuit. I don't know. Maybe they will. What the hell do I know? But she's not being served in that manner from what it sounds like anyway. So I don't know who it is that these additional 2 lawsuits will be on behalf of. There's speculation that it will be on behalf of Lindsie and Chase. Whether or not that's true, I have no idea. So I guess we'll just have to wait and see. But yeah, as far as the class action goes, I don't know anything about that. I know that it was discussed, but yeah, I'm right there with you with the knowledge on that. I don't know. I didn't really put much into that because defamation is just, it seems like it's so hard to prove as it is, and then to do it on a class action scale, that just seems like a near impossibility. I think. I mean, you would have to have absolutely the right circumstances, I think, and the right attorney arguing it. So I never really put much stock into that whole idea, I think. Okay. All right. So I'm going to start reading this then. All right. So this was filed on the 12th. So again, this is the plaintiff's opposition to defendant's motion to dismiss. So we read the motion to dismiss from, from Katie, how the letter I just read to the judge saying, hey, can we just push back the or whatever on hearing dismissal or whatever for this case, because we want to wait until the criminal court case happens and then take it from there. And so this is the plaintiff saying, no, we don't agree to that. I think, don't quote me, again, defendants, whatever, and had monetized a years-long campaign of lies directed at plaintiff Michael Todd Chrisley. In particular, they have repeatedly accused Mr. Chrisley of 1, attempting to extort his own daughter by threatening to release a sex tape featuring her and a man other than her then husband if she would not lie to criminal investigators, and 2, attempting to extort Ms. Paulson herself. Defendants have used these salacious falsehoods to drive traffic to their social media outlets, broadcasting them to an audience of thousands in order to reap the resulting ad revenue. Oh, I know what they're talking about with the attempting to extort. That was recent, wasn't it? It was like, I don't know, it was the end of last year or something, I think. Mr. Chrisley now seeks, through this lawsuit, to hold Ms. Paulson without a crystal ball to account. Defendants have responded with a motion to dismiss that attempts to rewrite not just the defamatory statements at issue, but also controlling law. Their motion raises a series of issues typically left to the jury to decide and fails to cite even a single case involving defamation that was resolved on a motion to dismiss. Defendants first contend that the fair and accurate reporting privilege shields Ms. Paulson's falsehoods. But that privilege does not apply because, among other things, none of Ms. Paulson's defamatory statements report on or summarize governmental proceedings or public records. Ms. Paulson further argues that Mr. Chrisley must, at the pleading stage, come forward with evidence proving that her alleged defamatory statements are known lies. Not so. Mr. Chrisley need only plead, as he does, that Ms. Paulson knew her statements to be false or that she acted recklessly in making them. Ms. Paulson also contends that isolated phrases from her social media posts accusing Mr. Chrisley of extorting her are literally true. Do you think literally was just like thrown in there for like a little dig? Like, are literally true? It's funny. But it's axiomatic that the defamatory character of any particular statement must be construed in the context of the article as a whole. The fact that individual phrases are true does not relieve Ms. Paulson of liability when, in context, they plainly accuse Mr. Chrisley of criminal activity. Accordingly, defendant's motion to dismiss should be denied. Background. Plaintiff Todd Chrisley is a real estate investor and star of USA Network's reality television program, Chrisley Knows Best. The program follows Mr. Chrisley and his family. Okay, we already know all this. Ms. Chrisley blamed her family and particularly her father for her exclusion from the show and lashed out in the media over the following years. As relevant here, on October 17, 2019, she appeared on the talk show Dr. Phil. During the interview, she recounted a meeting with her father. In Ms. Chrisley's account of the meeting, she denied having an affair with a state official involved in an investigation into her family. She also related that Mr. Chrisley told her that Chase Chrisley, her half-brother, had obtained a sex tape featuring her and a man other than her then husband for $5,000. She agreed when asked by Dr. Phil that she viewed this as a veiled threat. Lindsie Chrisley's account of this meeting was inaccurate. It is simply false that Mr. Chrisley made any veiled threat against her. Defendant Catherine Paulson is an internet personality and blogger producing content with a focus on reality TV. Through her company Without a Crystal Ball, LLC, she monetizes her social media presence on YouTube, Twitter, Instagram, and Facebook. She publicly claims to be close friends with Lindsie Chrisley, a relationship that helps distinguish her from competing internet personalities with a similar focus. Over the last 2 years, Ms. Paulson has frequently repeated the falsehood that Mr. Chrisley attempted to extort his daughter by threatening to release a sex tape if she refused to lie to the authorities investigating her family. Indeed, Ms. Paulson has gone further than merely repeating this falsehood. She has embroidered it and variously claimed and implied that she possesses independent, corroborating evidence to bolster it. Her false statements include the following. On October 19th, 2019, Ms. Paulson posted a now deleted YouTube video lasting more than 45 minutes in which she speculated at length that Mr. Chrisley was involved in a plot to extort his daughter. Ms. Paulson stated that Chase Chrisley and, quote, possibly Todd, were coercing Lindsie and Robbie. The assumption here is that Chase was attempting to obtain any videos or new photos that he would have of Lindsie in an effort to have leverage over her in order to threaten her to cooperate with the investigation. And another now deleted YouTube video from October 19, 2019. Oh, another. So there were 2 of them that day? I don't doubt it. Ms. Paulson falsely claimed that somebody anonymously from the Chrisley Knows Best crew actually reached out to me to let me know they watched Lindsie Chrisley's interview on Dr. Phil, and they said, I believe her. I'm not even lying. Ms. Paulson goes on to falsely claim that Todd Chrisley approached Lindsie and told her about new photos in a video that her brother Chase had obtained for $5,000, and that she needed to be careful about what she said, or things wouldn't end well, with the implication that the PR team might leak a story with containing those new photos, or that she was having an affair with a Georgia state official. In another YouTube video dated October 23, 2019, Ms. Paulson again stated at length the allegation that Mr. Chrisley threatened to release the sex tape if Lindsie Chrisley did not cooperate. She further stated that tweets Mr. Chrisley had posted much earlier were clearly threats that he's going to release this tape. In a January 5th, 2020 YouTube video, Ms. Paulson again repeated the allegation that Mr. Chrisley had attempted to extort his daughter with a sex tape. She stated, among many other similar statements, Who would want to read stuff from a father that is constantly saying negative things about you? And hell, threatening to trying to buy a tape between you and your ex because they are mad at you because you would have lied to federal prosecutors, or federal prosecutors, really into an investigation into his alleged tax evasion. Why, after that whole paragraph, why even throw in the alleged why? Like, wouldn't that save you? What, really? In a series of tweets dated June 25th, 2020, Ms. Paulson repeated again the falsehood that Mr. Chrisley threatened his daughter with releasing a sex tape. Ms. Paulson alluded to receiving private details or information from Lindsie Chrisley and stated with regard to the allegation that Mr. Chrisley attempted to extort his daughter with a sex tape, "I believe her." And yet another tweet dated August 12, 2021, Ms. Paulson falsely claimed that Lindsie Chrisley provided evidence for the alleged sex tape extortion by Todd Chrisley and Chase Chrisley. In reality, Lindsie Chrisley provided no evidence at all indicating that Todd Chrisley had attempted to extort her with a sex tape. On August 13, 2021, Ms. Paulson created a Facebook post implying that Mr. Chrisley was involved in a plot to extort his daughter by stating, in a text message allegedly between Todd Chrisley and Lindsie Chrisley, Todd allegedly tells Lindsie that she was worth $5,000 to her friend. He claims to have knowledge of the video. On August 21st, 2021, Ms. Paulson made an Instagram post discussing Mr. Chrisley and referring to the allegation that Mr. Chrisley attempted to extort his daughter with a sex tape and naked pictures. She noted that Lindsie Chrisley had posted a screenshot of Todd Chrisley and Lindsie talking about the sex tape and a $5,000 price tag. The screenshot indicates that Lindsie Chrisley did not believe her father to be involved in any effort to extort her by threatening to release a sex tape. Ms. Paulson concludes the post by stating, "Extortion is a felony," referencing the false claim that Mr. Chrisley attempted to extort his daughter. Ms. Paulson broadcast these false statements to an audience of thousands, despite knowing them to be false. She did so to strengthen her relationship with Lindsie Chrisley and to drive traffic to her social media accounts for her own financial benefit and that of her company. Ms. Paulson knew these statements were false based on her relationship and regular communications with Lindsie Chrisley. Ms. Paulson further understood the sensationalistic, improbable nature of the allegations. Ms. Paulson also knew that she had not received inside information from an anonymous Chrisley Knows Best crew member or from Lindsie Chrisley herself corroborating these statements and falsely claimed and implied otherwise to bolster her own credibility. And Ms. Paulson eventually removed a number of the publications at issue from her various social media pages, again, demonstrating her knowledge of their falsity. In addition to the above, Ms. Paulson has recently taken to claiming that Mr. Chrisley attempted to extort her as well. In a series of social media posts, Ms. Paulson falsely stated that in responding to her serial harassment, Mr. Chrisley had acted criminally. These claims include the following. I remember this video. Wow. Oh, no, this is Twitter, but still, she did a video about it too. On August 6, 2021, Ms. Paulson wrote on Twitter, "Today we served Todd Chrisley's attorneys with a cease and desist for defamation, extortion, and tortious interference for the threats he's made over the past 3 weeks. It's against the law to threaten to destroy someone unless they provide private information. Extortion is a felony." The same day, Ms. Paulson wrote a post on Instagram with a screenshot of the above tweet stating, "Extortion is a felony and punishable by prison time. At this time, we have not reported this to the FBI. Threatening someone to hand over private information or else you will ruin them is extortion and under the law is a criminal felony. We take these threats seriously as Mr. Chrisley is on bond for federal charges related to a 9-count indictment." Again, these accusations of criminal conduct were false. Mr. Chrisley never attempted to extort Ms. Paulson. Despite knowing these statements to be false, Ms. Paulson broadcast them to an audience of thousands. By spreading the foregoing falsehoods, Ms. Paulson has damaged Mr. Chrisley's reputation and caused him emotional distress. Legal standard. Defendants moved to dismiss under Minnesota Rule of Civil Procedure. Under Minnesota's liberal notice pleading standard, motion to dismiss for failure to state a claim will be denied. If it is possible on precedents or whatever. I'm not going to read all that. Okay. Okay, so we'll go down to argument. The fair and accurate reporting privilege does not apply. Generally, the common law republication rule provides that a speaker who knows or should know that a statement is false and defamatory but repeats it nonetheless is equally as liable for the defamation as the original speaker. Defendants first argue that Ms. Paulson's defamatory statements fall within the fair and accurate reporting privilege, which is an exception to the common law republication rule and an affirmative defense. It shields from liability one who publishes an accurate and complete report or a fair abridgment of public proceedings or public records that would otherwise be defamatory. Defendants contend that the privilege applies here because Ms. Paulson's defamatory publications are drawn almost wholly from a police report and a are drawn almost wholly from a police report and a televised interview Lindsie Chrisley sat for with Dr. Phil. But that factual premise is simply incorrect. None of the statements at issue summarizes or abridges a police report. Only a few even refer to Lindsie Chrisley's interview with Dr. Phil, and many rely on or summarize other non-privileged sources, such as various social media posts by Lindsie Chrisley. Moreover, defendants' defamatory claims that Mr. Chrisley attempted to extort Ms. Paulson herself are completely unconnected to the cited police report and interview. Defendants make no effort to explain how the fair reporting privilege attaches to any particular statement at issue. They simply invoke this affirmative defense and leave it to Mr. Chrisley and the court to puzzle out how it might apply. Even if Ms. Paulson's reporting did summarize or abridge a police report made by Lindsie Chrisley, the fair reporting privilege would not apply. As a restatement explains, an arrest by an officer is an official action, and a report of the fact of the arrest or of the charge of crime made by the officer in making or returning the arrest is therefore within the conditional privilege covered by this section. In stark contrast, statements made by the complainant or other witnesses outside of a public proceeding or official statement, such as Lindsie Chrisley's complaint, are not privileged under this section. This is just like precedent information. I'm not reading that, whatever. Okay, Ms. Paulson's reporting regarding Ms. Chrisley's interview and Dr. Phil likewise fails to trigger the fair reporting privilege. Indeed, defendants acknowledge as much, admitting that there may be some disagreement as to the application of this privilege to the Dr. Phil interview. The fair reporting privilege applies solely to reports of governmental proceedings and public records. Minnesota courts have taken an incremental approach in defining the privilege and have applied it only in limited circumstances involving governmental proceedings or statements. The undersigned is aware of no authority applying the fair reporting privilege to statements made on a daytime talk show. Defendants cite no such authority, nor do they otherwise provide a legal basis for this court to expand the privilege far beyond its recognized bounds. Finally, even if the publications at issue were summarized or abridged privileged sources, the privilege is lost if one makes additions of their own that would convey a defamatory impression, impute corrupt motives to anyone, or indict expressly or by innuendo the veracity or integrity of any of the parties. Why is this not moving? If a defendant ventures beyond summarizing or abridging a public proceeding or record, the entire report then would be subject to evaluation as any other allegedly defamatory statement. Ms. Paulson's publications include many defamatory additions not found in the cited sources. Among other things, Ms. Paulson has claimed that Mr. Chrisley himself attempted to purchase the sex tape of his daughter, and Mr. Chrisley threatened his daughter with the release of nude photographs in addition to the sex tape. And 3, Mr. Chrisley threatened to release the sex tape through social media. What's it? Defendants assert in passing that Ms. Chrisley's false account of a meeting with her father on Dr. Phil consisted of statements made by the eyewitness whose account has presumptive veracity. Okay. I just wanted to see what that was. Okay. Ms. Paulson has also repeatedly opined on the party's credibility, cited additional non-privileged sources to bolster the false story, and speculated regarding Mr. Chrisley's corrupt motive. Okay. Corrupt motive. Mr. Chrisley. There's no end of the thing. Okay, whatever. Mr. Chrisley has adequately pled actual malice. Public figures bringing defamation claims must show that a defamatory statement was made with actual malice, meaning made with the knowledge that it was false or with reckless disregard, or whether it was false or not. Of whether it was false or not. Defendants argue at considerable length that Mr. Chrisley has not adequately pled that Ms. Paulson made her statements with actual malice. They base this argument on a flawed premise that Mr. Chrisley must put forth evidence proving that the alleged defamatory statements are known lies or were made. Where did they jumped again? I can't see where I left us now. Actually, with evidence that the defamatory are known lies or were made with reckless disregard at the pleading stage. Sorry, my screen like kind of freezes and then it jumps and then I lose my place. Minnesota has adopted a liberal notice pleading standard under which okay, I'm not reading all that. If you care to learn Minnesota law, you can look it up. I'd much rather just have the law told to me than have to read about it. Sorry. Yeah. This much I kind of knew, though. It's like in science terms, though, I think they refer to it as you can't prove a negative or something like that. Indeed, requiring that Mr. Chrisley provide conclusive proof to substantiate his claims at the pleading stage would be unconstitutional. And in invalidating Minnesota's anti-SLAPP law, the Minnesota Supreme Court held that requiring a plaintiff to produce evidence to sustain its allegations and responding to emotion. Okay, yeah, whatever. But yeah, that's what it sounds like. It sounds like she made the claims. Now he's saying they're lies. And then she's saying, well, prove to me it didn't happen. Yeah, how do you prove something didn't happen? No, if you're saying something happened, you have to prove it happened. The responsibility of proving it falls on the person making the claim, not the person refuting the claim. Okay, Mr. Chrisley repeatedly alleges that Ms. Paulson knew the defamatory statements at issue to be false when she made them, or at least acted with reckless disregard as to their truth. He thus satisfies the pleading standard set by Minnesota law. In fact, Mr. Chrisley goes well beyond the requirements of notice pleading and alleges a number of circumstances demonstrating that Ms. Paulson knew the statements at issue to be false, or at least recklessly disregarded that possibility. Among other things, Mr. Chrisley alleges that Ms. Paulson fabricated sources to bolster the defamatory statements, ultimately deleted some of the most egregious false statements from her social media accounts, ignored the inherently improbable and sensationalistic nature of the statements, had a strong financial motive to disregard the falsity of her statements, and regularly communicated with Lindsie Chrisley, who knew the statements to be false. A statement may have been made with actual malice if it is fabricated by the defendant, is a product of his imagination, is based wholly on an unverified anonymous telephone call, or if the publisher's allegations are so inherently improbable that only a reckless man would have put them in circulation. That's interesting. I want to repeat that. I just said I don't like reading, law, but this is interesting. The way it's explained in this, I don't even know what that is. It's a case, I think. I don't know. It's precedent. A statement may have been made with actual malice if it is fabricated by the defendant, is the product of the defendant's imagination, is based wholly on an unverified anonymous telephone call, or if the publisher's allegations are so inherently improbable that only a reckless man would have put them in circulation. So basically, what it's saying is where this relates to Katie, or where Katie's concern in this would be, is that it could be considered actual malice. If what they're alleging she did do, it could be considered actual malice because she would have done this without verifying any information about the anonymous telephone call or the caller. And then she turned around and took this incredibly outrageous claim that's, very likely untrue. Definitely nothing going for anything for yourself to support your outrageous claim anyway. And you take this information without that claim or without that evidence, and you throw it out into circulation anyway. Like, that is just incredibly reckless. It's so reckless, in fact, that it can then therefore be considered actual malice. At least that's how I'm reading the sentence. These allegations are far more detailed than Minnesota law requires. Maybe. That probably can't really speak to, I don't know. But it sounds good. Finally, defendants argue that individual sentences in Ms. Paulson's social media posts accusing Mr. Chrisley of extorting her are literally true when viewed in isolation. It's killing me every time I read that now. But the defamatory character of any particular statement must be construed in the context of the publication as a whole. Ms. Paulson's statements viewed in context plainly carry a false and defamatory meaning. Statements are defamatory per se if they falsely accuse a person of a crime. In regard to false accusations of a crime, the words need not carry upon their face a direct imputation of crime. And it is sufficient if the words spoken in their ordinary acceptance would naturally and presumably be understood in the connection and under the circumstances in which they are used to impute a charge of crime. Okay. Here, an ordinary reader would understand the two social media posts at issue to impute the false charge that Mr. Chrisley committed the felony of extortion by making threats against Ms. Paulson, whether or not individual sentences in those social media posts are literally true in isolation. As to the first publication, defendants attempt to rewrite Ms. Paulson's words to lead their defamatory meaning. They assert that the sentence, "Today we served Todd Chrisley's attorneys with a cease and desist for defamation," is literally true and cannot convey a defamatory meaning. But that is not what Ms. Paulson wrote. Defendants omit, oh my gosh, she does this all the time too. Like when she's just telling her view, her side of the story or whatever, this is literally what she does. And yes, I'm using literally correctly, I'd like to add. But that is not what Ms. Paulson wrote. Defendants omit the latter half of the sentence. The full sentence reads, today we served Todd Chrisley's attorneys with a cease and desist for defamation, extortion, and tortious interference for the threats he's made over the past 3 weeks. The tweet continues, it's against the law to threaten to destroy someone unless they provide private information. Extortion is a felony. The only way to understand this social media post as a whole is that Mr. Chrisley committed the felony of extortion by making threats against Ms. Paulson. Indeed, that accusation is explicit in the portion of Ms. Paulson's tweet that defendants conspicuously omit from their brief. The second publication, see, now if I were a judge and I was like ruling over like some ridiculous social media, the case is ridiculous in the manner of which this shouldn't have happened in the first place to become a case. So when I call it ridiculous, that's what I'm referring to. I don't at all find it ridiculous for someone to want to restore their reputation after it's been tarnished. Absolutely. I get that. But it's ridiculous that I had to get to this point. Just saying. So if I were a judge and I were looking at this case and thinking it's ridiculous that we have to be here at this point. And then I read that the shit I was reading from one party in this case was omitting half of the information. In the important part, I would be pissed if I were that judge. I'd be like, what the fuck do you think you're up to? But you think you're going to get away with? I mean, come on. Excuse me, because it seems like my attention is needed momentarily. I'll be right back. It's funny that we're reading about like accusations about what's the word I'm looking for? Tax evasion or whatever. I'm just not doing my taxes like today. Well, the accountant is, whatever. It's my first time having to include any AdSense payments or whatever into my taxes. So it's a learning experience. Although for years I was an independent driver for a delivery company. So it considered an independent contractor or whatever. So you're self-employed, it was considered. So I have a little bit of knowledge in the area, but there's like a lot more write-offs though with YouTube than there was with that. Anyway, my bad. Back to this. Like I was saying though, if I were the judge, I'd be pissed. I would be pissed about that. Like that would get under my skin. The second publication incorporates the first and is defamatory for that reason alone. It also elaborates on the accusations of the first publication, stating extortion is a felony and punishable by prison time. At this time, we have not reported this to the FBI. Threatening someone to hand over private information or else you will ruin them is extortion, and under the law is a criminal felony. Criminal felony. All right. We take these threats seriously, as Mr. Chrisley is on bond for federal charges related to a 9-count indictment. Again, the statements in context plainly convey a false and defamatory meaning that Mr. Chrisley made threats that Ms. Paulson takes seriously to the point that she considered reporting them to the FBI, and that the threats constituted extortion and a felony punishable by prison. See, no, it's not a felony. It's a criminal felony, okay? If the lawyers may want to correct that. All right. What's more, the language is unambiguous in imputing to Mr. Chrisley the charge of committing a criminal felony. My bad, I take it back. I take it back, sorry. I can start that again. What's more, the language is unambiguous in imputing to Mr. Chrisley the charge of committing a criminal felony, as opposed to engaging in more rhetorical hyperbole. This is defamation per se. In any event, the statements above are, at a minimum, plainly capable of conveying the defamatory meaning that Mr. Chrisley attempted to extort Ms. Paulson. If words are capable of a defamatory meaning, a jury then must decide whether they are actually defamatory. Conclusion. Defendants have spent years spreading vicious falsehoods concerning Mr. Chrisley for their own gain. They cannot escape liability by donning the ill-fitting mantle of journalists, nor by pretending that they did not say what they said. Accordingly, the court should deny defendant's motion in its entirety. So, there's that. Now, the fifth, there's more. I don't even remember what this is. Okay. All right. So this last one was filed on the 13th April, well, yesterday. And it looks like, what the hell? I don't need that open. And I just closed my Finder. Okay, there it is. So this is a letter from Todd Chrisley's attorneys to the Honorable Catherine McPherson. And it was filed, like I said, on yesterday, April 13th. And the letter goes on to state, Dear Judge McPherson, Plaintiff Todd Chrisley writes in response to the letter from defendants dated April 2nd concerning the upcoming hearing on defendant's motion to dismiss. Defendants request that the court delay the imminent hearing on their motion to dismiss pending the conclusion of an upcoming trial in the United States v. Chrisley, as defendants apparently concede that case concerns subject matter unrelated to this litigation. While defendants contend that tangential issue, I can't fucking talk, may be addressed during the trial that may bear on issues relevant to this proceeding. Defendants neither explain nor support that assertion, and it is unclear how the trial could impact defendant's motion to dismiss. As detailed in plaintiff's opposition, the arguments raised in defendant's motion fail as a matter of law, regardless of what may transpire at the upcoming trial. Moreover, the trial date in the above case was set months before defendants filed their motion to dismiss and secured the upcoming hearing date. Defendants were plainly aware of it. Indeed, they noted the trial date in their memorandum of law supporting their motion to dismiss. Nothing has changed since then, except that plaintiff started to pursue discovery. As explained in plaintiff's recent discovery letter to the court, defendants have attempted to justify their refusal to meaningfully participate in discovery by reference to their unresolved motion to dismiss. This recent effort to delay the upcoming hearing, which defendants initially sought to hold at the earliest possible opportunity, raises concerns that defendants will continue to cite their unresolved motion as a justification for their refusal to honor their discovery obligations. Accordingly, while there is no need to delay the resolution of defendant's motion to dismiss, should the court reschedule the hearing on that motion, plaintiff respectfully requests that the court utilize the time reserved for the hearing to hold a conference on the discovery disputes raised in plaintiff's discovery letter. Respectfully, okay. So that is where we are at with the Todd Chrisley versus Katie Joy without Cristobal lawsuit. That is where we're at. They're saying we need this information. Katie's saying, I don't hear anything. Do you hear anything? Basically, and they're saying, yo, make her listen. All right. So let me go back here. Chat. Let me check out the chat. I haven't been here in a minute. Let me scroll up. All right, so I'm not seeing any orange. So, oh wait, there's one. Oh wait, oh, this one I read earlier. Okay, I must have scrolled up too far. There's one. Oh, I know I was muted, Megan. I was talking to, I'm not still muted, am I? Okay, no. I meant to be muted there for a moment. Thank you. For those of you who are new here, I oftentimes will sit here and talk to you while muted because I forget. So. Okay. All right. It doesn't look like there's anything at the moment in chat. I will try and keep an eye on it now that I'm done reading that. Someone also sent me a video though, or sent me a link to a video. I want to download it though before I play it because I don't know how long I'm going to be able to play it for after I play it. So let me just real quick download that. And I would happily give them credit for this, but they asked that I not do so. But you know who you are. Thank you. Oh, in fact, this person, this person also found me those clips that I've been asking for like 2 weeks. Like they found it for me. Like, I have them. I have all the clips needed for this video I've been talking about for like weeks. And I've been talking about it so much now that by the time I do release it, people are probably going to be like, yeah, what's, like, I feel like I hyped it up too much or whatever. I probably did. But I finally have all the clips. So now I have to just think of how I want to put it together. So, I mean, I know how I do, but do I want to do a kind of a factual place or coming from a factual place or a little bit of satire, humor? I think I want to go satire humor route. So, all right, real quick. Wait. No. Oh, shoot, it's Facebook downloader. That's not going to work. Oh, okay, cool. I must have grabbed the right one. All right, so less than a minute left, and then I'll start playing it. what's this in a minute left? Now we're back in a minute. I don't know why. My internet's not been working very well lately. Oh, thank you so much for the super sticker, Lola Layla. Thank you. Awesome. Right, this will be done downloading very shortly. And I think we're done. All right, yes. Okay, so now, as many people know, if you try to go to Katie's channel to watch any of the Todd Chrisley videos, you would not have been able to find them. Apparently, not all of them, though, were like privatized or removed. Some were unlisted. I guess some are now public again. I have a link here to an unlisted one, so we're going to go ahead and play it. And I already downloaded it, so if somehow we lose the privilege to view this, then I can just pull up the download. And this is so this is from I'm not gonna be able to see the date, am I? It says YouTube comment search. For some reason, like it makes viewing the date like it just stops showing it to me. So I have to view the video in an app, and then I can see the date. So the date was January 5th, 2020. So a little over a year, 2 years ago. Yeah. 2 years and a few months ago. And this video is titled Todd and Lindsie Chrisley's Bitter Feud Continues with Todd, quote unquote, cutting the cord. Why is the O a 0 instead of an O? That's weird. To which she writes, Lindsie and Todd Chrisley have been trading barbs for months on social media. Todd Chrisley seemingly sent a message to his daughter about cutting her off after she shared a story about parenting. Okay, so it's like 11 minutes long. I thought, after the reading, why not watch this? I'm skipping the intro, by the way. No.
Again, my hair fixed. Thank you, Nikki, for doing an amazing job and smudging out my roots for a soft look. I am excited about hairstyle. I am so sorry for not knowing I've gone live. Hey, welcome to my channel. If you are new, brand new, welcome. If you have not hit the subscribe button, make sure you hit subscribe at the bottom of the channel. Also, if you are interested in becoming a member, the link is in my description. Welcome to all of my members. Thank you so much for supporting the channel. And to everyone, all of my subscribers, hey, what's up? So we haven't checked in with the Chrisleys in a minute. And I was like, you know what? We need to have a Chrisley connection. We need to talk about the Chrisleys. We need to just, dig in. Since Todd Chrisley seemingly never knows when to stop talking about his daughter. And I was digging through some of his recent, well, actually, this completely happened by accident. On my Instagram, I was looking through the stories of the people I follow, and one of the people I follow happens to be Lindsie Chrisley. And I was reading one of her stories, and I was like, oh, that's so cute. I love this because it matched something that I feel about my son. And this is what it said. Your children don't belong to you. You're on borrowed time with them. Your mission should choose to accept it, is to build a better human being, not to build a mini version of you, and all your deflated hopes and dreams. Help them become the best them, not the best you. And I absolutely loved it. It was funny because when I saw it, I took a screenshot of it. It was like a quote that I feel like I wanted.
So just saying, ask the question. So does she have a different lawyer for the 7M lawsuit? I have no idea. From what I've seen on the filing for the 7M lawsuit, I don't think that there is a lawyer listed. I'll double check though as this is playing.
Class all over my house, just as a reminder of parenting, and also sort of a belief system that I have that your children are not your property. They are their own autonomous people, and that we should be making choices for them to help them become the best versions of themselves. So when I saw it, I was like, oh, that's so sweet. Oh, I love this. And then I took a screenshot of it, and I wasn't really going to do anything with it but save it for myself. But then as I'm scrolling then through my page, I see this, and it says, fools take a knife and stab people in the back. The wise take a knife and cut the cord and free themselves from the fools. And then he wrote, think about it. And I was like, Oh my God, that's totally a response to Lindsay's story. It's 100% because she posted this yesterday, last night rather, and it was around like 15 hours ago when I grabbed the screenshot. So late last night she posted this, and then he posted this about 3 hours ago. Because I feel like he probably saw this and was like, "Oh, that's about me." Because I'm of the belief that Todd believes that everything's about himself. That's just my opinion. But I could be wrong, but he seems to be sort of narcissistic in that respect. And he's been making a lot of statements about Lindsie recently. In fact, on a podcast from December 11th, he actually talked about estranged family members. And during a period of where he and Lindsie, his wife Julie, and his son Kyle were talking about preparing for the holidays and talking about, dealing with estrangement in the family for the holidays, he actually started talking about Lindsie, which I thought was weird because he's always like, "I'm not going to talk about Lindsie anymore. I'm done talking about Lindsie." And then he's always talking about Lindsie. And she has really not been saying anything about her dad since the Dr. Phil episode aired. She's really vowed herself not to talk about this publicly anymore and to keep everything offline. So when I saw this, it didn't scream to me like, "Oh, she's sending this to her dad." Although, I mean, indirectly, maybe it could have been. In his mind, he probably took it as a personal jab at him. So when I saw this, it fit with something that he had said in the December 11th podcast on Chrisley Confessions. And on the podcast, he talked about how Lindsie is...
Okay, I'm going to pause this for a moment. I'm going to share another screen just to show you how there's no attorney listed on the 7M lawsuit. So here, this is from the courthouse or the court website for the state of Minnesota, U.S. federal court. And here it says Plaintiff, 7M Films, and attorneys active. And you see, there's Robert Shin, attorneys active. And then defendant Catherine Paulson, no attorney active. And same thing for Without a Crystal Ball. So it appears that there is no attorney yet listed, or at least there wasn't at the time of this filing. There may be one now. I can't imagine Graham is handling that. I mean, I don't know. Would someone really want to have the same lawyer working the several or more than one case for them at the same time? That's what I would be worried about. I mean, if you're going to pay, you're going to have to pay double the fee regardless because it's two lawsuits. So wouldn't you rather pay one fee to one attorney so they can focus on that lawsuit and then pay an additional or the separate fee, the second fee to another attorney so they can focus on that lawsuit? I wouldn't want to bog down one attorney regarding, several cases and then end up having to pay for that when, I don't know. That doesn't seem like a wise idea to me, but what do I know? It's not like I've spent much time in any court, let alone federal court over defamation. So, okay. Back to this.
He felt like he had served his purpose for Lindsie, served his purpose. He said after, raising her and perhaps after all of these years, maybe he has just served his purpose in her life and that it would be better that they just sort of separate because, at this point in time, it doesn't seem as though the relationship is going to be repairable. And Julie sort of interrupts him and says, "Well, I don't think that's true. I think you are always a parent no matter what happens. You don't stop being a parent just because you become adults," which is true. And then he sort of interrupts her and it gets very angry and abruptly says, "Well, as a birth parent," he literally starts separating himself as her father by referring to himself as a birth parent, not as the father. And he said, "It is not my responsibility to stay around while someone verbally abuses me and drags me in the public and tarnishes my reputation and speaks so negatively about me," and goes on and on and on about all these terrible things that Lindsie has said about him in the press, which to me was like, wait, what? Aren't you the guy that literally tweeted about her having sex with other men and how it was a shame to the family and how, you were tweeting about thank God for puppy cams and you were tweeting about how, she had this tape? And weren't you the same one in messages that Lindsie leaked where you're talking about, the disgracefulness of her having an affair when he himself had an affair, mind you, because he met Julie when he was still married to Lindsie's mother? So I'm like sitting here going, wait, what? Wait, who's been verbally abused? Lindsie? Lindsie was verbally abusing you? No, you can't be talking about Lindsie. No, that's not possible. I don't know. Anyways, so knowing that he said that on December 11th, when I saw this about cutting the cord, I knew exactly he was talking about Lindsie because Lindsie posted that message and then only a few hours later, he posted.
Okay, so in comments here, where was it? Lisa says, "I read on Reddit that she's supposed to go to court on the 20th of April at 1:30 for discovery. I may have read it wrong, but I don't think so." What I just looked up, I saw that she has an upcoming court date for the Chrisley lawsuit on April 27th. And then she has a motion hearing coming up in 7M or in the 7M lawsuit on May 27th. So if that helps. And I believe that these are like Zoom calls or whatever appearances. And I believe that they're public too. I could be wrong about that, but.
Post that. And he seems to use his Instagram as a way to send subliminal messages or cryptic messages to people in his life that he wants them to see, which is funny because I'm pretty sure that she probably hasn't blocked. Because who would want to read stuff from a father that's constantly saying negative things about you and hell, threatening to release trying to buy a tape between you and your ex because they're mad at you because you wouldn't lie to federal prosecutors federal prosecutors related to an investigation into his alleged tax evasion, as according to what Lindsie said to Dr. Phil earlier this fall. So I'm like, wait a minute, Todd, like, why are you always the victim? Why is it always him? Like, he's got to be the most unlucky person in the world, right? Like, he is the most unlucky person in the world that, like, everyone else, it's always everyone else's fault, which is another sign to me that he may be a little bit narcissistic. So it seems like even though Lindsie is trying to, like, calm the waters and not do anything, he can't stop talking about it, which got me thinking about why would he be doing this? Is he still trying to, like, what's going on with the court case? Is there something happening? He did file a motion in court in Georgia to have them suppress evidence and drop the charges against him because he believes that in a motion that was filed in court in December, he believes that the government illegally obtained the information because he didn't have a tax lien. And apparently the federal government subsequently took the stuff that was seized by Georgia illegally. And so therefore they don't have a case, even though they have a lot of evidence outside of what was in the storage lockers. I don't know. I feel like no matter what he's doing, he's trying to grasp for straws. And then his other lawsuit where he's trying to sue the rogue tax guy in Georgia seemingly seems to be falling apart because that guy, Josh Waits, requested that the court actually dismiss it on grounds that they can't sue him because he was working for the government. You can't.
I'm going to just turn the camera off for a moment, but I'm still here, just so you know.
Sue the government for doing an investigation on you. So I feel like he's losing people to throw targets at. And so now he's just going to be like, well, back to Lindsie. I'm done with Josh. It's not working talking to the government. So back to Lindsie, my favorite scapegoat, allegedly, my opinion. So I don't know what your thoughts are. Like, do you hope that at some point he'll stop these barbs and stop sort of going after her? I do. I hope so, but I don't know that he will. With the motion that was filed in court, there's an expectation that the judge will respond to the motion within the next couple.
Yeah, I kind of have to call bullshit on that whole thing. When she says, I don't know, I kind of hope that he'll stop. If everyone stopped doing the things that you're talking about, then what the hell would you be talking about? Like, I'm not saying, don't get me wrong. Like, I'm not saying you shouldn't want things like that to stop, sure. But just, I don't know, just be more transparent about shit. That's whatever. I'm nitpicking now. I get it. I'm getting petty.
Months. I know the next pretrial hearing is not scheduled again until like April. So that court case is really it's going really slow, the federal case against him, but it's still going. Nothing at this point has been dropped. There are still at least 12 indictments that he is facing, and he's also facing up to 30 years in prison. So with a looming prison sentence, now it's Lindsay's fault, and he's cutting the cord. There we go. All right, you guys, I'd love to know what your thoughts are. Do you think that Lindsay's statement was about her dad, or do you think it was like innocuous and about parenting in general? I took it as parenting in general because I was like, I love this. And then what do you find about his response? These are up to you. It's up to you to decide. I share my opinions. Now you share yours down in the description. Before you go, make sure you give this video a thumbs up and also subscribe to the channel if you have not. All right, you guys, I'll be back later. Bye.
Okay. Where am I? Okay, give me 1 second. I just want to grab something else to drink, and then I'm going to read Lindsay's Instagram post from yesterday. This is a long read too, but it's a good read. It's good. She pretty much throws, at least from my point of view, it looks like she just throws Katie right under the bus. So I'll be back in 1 second. Oh, shoot. I'm coming. Okay. All right. Guys, break this stuff in my hair that's supposed to, I don't know, make it shine or something, but it's like caustic breathing it in. It feels like it's just like suffocating you. It's horrible. But it works. All right, so for those of you not aware, Lindsie Chrisley made an Instagram post yesterday where it seems like she does address the drama regarding a YouTuber and the alleged attempted extortion over a sex tape. She does not come right out and name Katie, but I don't, who else could it be? So with that, first let me check chat real quick. Make sure we're all good here. Where are these court docs I looked at? Oh, I didn't get them from Pacer. They're on here. I'll put in the link to the website. Okay. So this is the Minnesota Judicial Branch, Minnesota Court Records Online, MCRO is what it's called. And here's the link. Here you go. That's what I do. I just, and I, when it comes to this website, I search her name. So I just put in, and you don't even need that much information because it's just covering the state of Minnesota. So I just put in her first and last name and then hit search and she comes right up. There's something else from Todd that just dropped. Oh, after you click on that website, you may have to hit case search or whatever. I don't know. Look, for some reason, I had to do that. Weird. Normally, I don't have to. Okay, I don't have anything for, all I have are the last five that I read here. The most recent document that's available here is the last one I read from the 13th. So there may very well be something additional filed from today. It just may not be up on the website yet. I don't know what the time frame is from the time it's filed to the time that it comes up on the website. So I have no clue, but I'll keep checking, and I'll definitely check too again before I end the stream, and I'll keep checking, till it comes up. But thank you. Thanks for giving me a heads up. I had no clue about it. All right. So here's Lindsie Chrisley's Instagram post from, I believe it was yesterday. Yeah, one day ago. Okay. Small too. I don't have my glasses, damn it. It has been said that courage is the most important of all the virtues because without courage, you can't practice any other virtue consistently. Tonight, I am showing up and allowing myself to be seen. Reality TV, media storms, podcasts, family feuds, divorce, legal battles, all things that I've navigated over the last few years. I've kept quiet for the most part and tried to allow the storms to pass. As I've tried to move forward in my life, I am constantly hit with Google alerts, living in fear, anxious, and tired. Chrisley knows sex tape. Chrisley knows best is family drama brewing. Chrisley sisters battle of the bikinis. Chrisley knows estrangement. People seem to forget we are human too. Things aren't always as they seem and as they are reported. Last week, I will share screenshots and stories, she says. Last week, the tape was being discussed yet again by a YouTuber that I have repeatedly asked to stop reporting on it. There's facts that surround this that no one publicly knows, and for anyone to continue to report on something without all the information is reckless and a threat to my mental and emotional health. What people do not know is that I have had knowledge of the alleged tape since 2017. Police reports were filed in 2017 and 2019. I currently am sitting on an extensive amount of knowledge regarding this entire situation and plan to share more information in the coming months. What I'm going to share today is that the information that is publicly known is not factual. The involvement that I have been led to believe that my dad and brother had looks very differently than what is reported. Misleading information is very dangerous, and this has been a huge lesson. I look forward to shedding more light on this situation in the coming months. In the meantime, I will be praying for the young woman who launched this scandal that has affected our entire life. What is done in the dark will eventually come to light. And she continues in comments. Oh, I don't know where the comment is. Maybe this is that it? Okay, I think this is it. Chrisley Sisters Battle of the Bikinis. There is no competition when you want everyone to win. We as women should take note. Collaboration and cooperation will beat competition every time. I wish more women realize that helping other women win, cheering her on, praying for her, or sharing a resource with her does not take away from the blessings coming to them. In fact, the more you give, the more you receive. Much love, always, Lindsie. And I'm guessing that was what was continued in comments. There's probably a shitload of comments, so let's see. Let me go out and see how many comments. Why is it not showing me? Okay, I don't know how many comments it would show me. What did she say about stories or whatever? That's right. I will share screenshots and stories. How do I get to stories? I don't even know how Instagram works, really. Do I go up here or something? The story is no longer available. I don't really know what any of this is. Okay. So, again, I just may not know or understand quite how to work stories. I apologize for that. And what am I being shared of? Let's see. I think this might have been what I read already. If it would, the PDF would actually load in the tab here. It's taking forever. Yeah, I read this one already. Thank you though, Reagan. Thank you. Oh, these, okay. Yeah, there's something up with my internet here. If I've been like, have I been like freezing a lot or jumpy or whatever? Because like my internet just doesn't seem to want to work on my devices at times. I don't get it. Like the only thing that has internet consistently is my phone, but I mean that's on a data plan, so yeah, better. Oh, but it shows up just fine here on the computer. But I'm gonna see it on the computer anyways. Oh, I get it. All right. I didn't know what the hell this was when I was looking at it yesterday. All right, save as. My computer is very slow. I try not to think about it when it does this. Like now my screen's not doing anything. I'll get very angry and I will start throwing shit or typing very, very violently into my keyboard, which again, I'm going to say, I'm going to do a shameless product placement here, even though I have no sponsorship or whatever. But this little keyboard here, it came with my iMac. It's Apple. Okay, this little wireless keyboard seat's thick or it's thin. You know, it's real light. Okay, but it's so durable. Like I beat the shit out of this thing all the time, and every key still works. In fact, I still have every key on it. That's amazing. I mean, I can take this with me places sometimes, and like, it's amazing. And the charge and everything is still like forever. It lasts forever. So if you're in the market for a wireless keyboard and you want a really good that's going to last you a while and really just take a beating, I highly recommend the Apple wireless keyboard. In fact, I don't think I'll ever bother with anything other than that. What's this one say? Oh, okay. All right. So then just the one screenshot, really. All right. Let me pull that up. Added. Here we go. All right, so there were two images in her stories from what I gather, and one of them is really just it did a picture of her, I guess, as we say. But this one though reveals a bit more information. So this is the picture that went along with her post that I just read. And also here is an incident investigation report, or police report rather, regarding extortion, harassing communication. And it says, I can't even see that. Brookhaven Police Department, Georgia. I was going to say, shit, someone's address is on there. I'm getting this off of Instagram. I mean, what the hell? I'm not doxing anyone here. But I can't really read that. So let me pull it up a minute. Second. All right, so it says, you don't want to let me download you? Fine. I'm going to screenshot you and look at you that way. How do you like that? Okay. Yeah, I can't read that. Extortion offense, other harassing communication, it says on the left there. There's dates and stuff, whatever. I'm not looking at them, but they all say 2017. So yeah, that's pretty much what it says. Yeah. So I'm guessing what this is to prove or to support is the claim that she's known about it since 2017 and that there was in fact an initial incident report filed in 2017. It wasn't just the one in 2019. That's what I'm taking away from this. Correct me if I'm wrong. right, so let me check out chat. Click on her picture. Okay. Like her profile picture or the the profile picture brought me something. You know. Some religious stuff. Easter stuff. So yeah, that's what I saw there for stories. Well, now this is interesting. Katie has not posted at all today, it looks like. In fact, the last time she posted it shows was 17 hours ago when she suggested Jeremiah Duggar. There was weird because I guess because he used his tongue in something like talking or whatever. I don't know. Weird. Yeah, you know, at some point you have to wonder, is it the things that you're now noticing people doing? Is that really like the weird perverted shit? Or is it the fact that you're seeing weird perverted shit and the normal things that people are doing? Sometimes you have to ask yourself the hard questions, I guess. All right, so let me go through chat here. Any questions? What's the status of her lawsuit with Steve McRae, and who do we believe the two lawsuits Todd Chrisley alluded to are from? The status of the lawsuit with Steve is he's putting it together, I guess. Yeah, I mean, it's the same status as it was. I think he's still just trying to raise all the money needed. It's come to find out it's not really that cheap to sue someone, which I think is kind of messed up, but whatever. I don't know. I feel like we all should be equally as entitled and able to get justice, not just criminally, but civilly too. I mean, it seems like civil courts is more or less like the court for the rich. And how is that American? So, but anyway, I'm not sure really exactly what the status is, but last I knew. So but as far as the other two lawsuits that Todd Chrisley is talking about, I have no idea who they could be from. However, I suspect that there could be two more lawsuits filed on behalf of Lindsie Chrisley and Chase Chrisley, but I could be 100% wrong on that. This is nothing more than speculation, and my speculation is based on very little. Although I do know of other people who had the same speculation, but they're basing it on much more information that they are privy to. I am unaware of much of the information, but I still suspect that it's these two. But I guess we'll find out. I could be wrong though. We'll see. Click on her picture. Okay, I did that. KJ posted 6 hours ago. Where? Why is shit? Not everything shows up for me. It seems I refreshed the page. Why isn't it showing up? Oh yes, she did. Okay. Well, I refreshed it. Why didn't it show up? God damn it. Whatever. Oh, she did. IBLP post the smear campaign. Oh, for fuck's sake. She's got to know that this gaslights people, right? I mean, she has to. She has to know that that has to be why she's doing it, I'm thinking. Right? These fucking posts right here. These posts. Like she has to know. She has to do it for the purpose of gaslighting. The smear campaign, when a narcissist has lost control of you, they want to make sure you are not looked upon favorably, especially when it relates to them. They also want to get their story out there before you or in case you tell people the truth about who they are. They want everyone to think they were victimized and you were, in fact, the villain. They have no problem out and out. What? They have no problem out and out lying. I thought the phrase was out and out lying. Okay. Twisting and telling only half the story. They make you into this horrible person and even project their bad qualities onto you. They do whatever it takes to make you look like the villain and them the victims. Anyone else has had one? I like just explode. Yeah, me too. Anyway, besides that, it's another Jeremiah Duggar post. Oh, how many Duggars has she really gone through so far? I mean, it's like she's just making her way down all 19 kids and counting. Jeremiah is next on the chopping block, it seems. Okay. Oh, boy. Thank you, Autistic Shield, though, for telling me. Let me know, because I did refresh the page. I don't know why. Facebook does that, too, at times, it seems. Yeah, she describes herself. Exactly. It's so gaslighty. It really is. Oh, boy. So, yeah, there's that. Oh, fuck off with this. She really does fancy herself as Leah Remini, doesn't she? Like, is there really anyone or many people anyways in this country who live with more entitlement than Katie? And she walks around like she's this constant underdog fighting anyone and everyone just to survive. Like, for fuck's sake. Okay, let me check one thing, and then I think I'm going to wrap this up. I have a few things it seems I have to get out, and I also want to start actually putting together my video tonight, so hopefully I can get it out this weekend. I mean, I knew that the chunk of the work was going to be in finding all the clips, and it was. But thank you to everyone in the community who helped and who sent me clips and everything, and like especially that last and final clip, I kept getting the date wrong. I kept thinking it was around this time frame or that time frame, and it appears I was kind of wrong. I was definitely wrong on one belief, kind of wrong on the other. So, like, I don't even know if I would have found it. So, thank you. You know who you are. You know. Thank you. And yeah, she's not doing anything really on Facebook, it seems. All right. Let me hang out and chat for a few minutes here. Yes, I thought arguing with COVID deniers and anti-vaxxers was full of face palming, but Katie is just as bad. A word, exactly. That's how Autistic Shill and I know each other, because we're both vaccine advocates over on Facebook. But yeah. So the term parent should be changed to Katie Jane. That's how entitled she is. Yeah, she is. I mean, and don't get me wrong. I'm entitled to. I acknowledge this. Don't get me wrong. But I'm also not going to walk around life like pretty much insulting those who aren't, or at least aren't as entitled as I am, let alone maybe much entitled at all, by acting as though I'm right there. Like I feel their pain and suffering. When, I can try, but I'm probably not going to really accurately succeed at that, seeing as though I've never felt it. So, yeah, Leah Remini always talks with her sources and acted like Todd was trying to wait and court. Oh, acted. Okay. Yeah. I kind of wish. Yeah, I was gonna say. Yeah, I read that wrong, DJ. I was gonna say no. I kind of wish that you would go after Scientology. Go for it. You go, girl. Take that shit down. I mean, think about it. If she succeeds, okay. If she doesn't, okay. Yeah, she's been bringing Scientology quite a bit lately. I wish she spoke on them. They shut her up real quick. I think she's bringing Scientology up for the most part because like it's like though it's not. I don't even think it's solely based out of California or LA. I think it's like Clearwater, Florida is like their home base of operations, I believe. But I mean, they've come to be known as like the religious cult to the stars, maybe I guess you could say, because they do have like the celebrity center there, whatever it's called in LA. And then here we have this quote unquote cult, as Katie calls it, pretty much surrounding dancers out in LA. So I think that might be why she's kind of conflating the two. I don't know. Well, okay, on that note, I'm going to wrap this up. I'm going to get to work on my video. And I want to thank everyone for being here and for watching. And I hope this has been fun and informative. It was for me. I'm a little annoyed that I had to watch your stream to find out you were on CNN News Report. Oh, yeah, I was interviewed by CNN. I was actually interviewed by CNN Global News out of Canada a couple times. The BBC, although that never aired. And an Academy Award nominated documentary filmmaker. And all of these were in regard to the vaccine advocacy on Facebook. The documentary filmmaker, though, that after COVID hit and shutdowns and everything happened, the anti-vax community got really quiet at first. So that from what I gather, that documentary just kind of ended up fizzing out. It had it not been for COVID, that definitely would have went somewhere, I think, and it would have went somewhere good. But COVID hit. And then, of course, when the mask mandates came out and the vaccine came out and the vaccine mandates came, well, then the anti-vaccine community rose up again. So now they're no longer quiet and they're gaining back their strength that I think that they lost throughout much of COVID. So, but yeah. I can put links to them. Just keep in mind, okay, when I did the interview, I was really fat. Okay. Like I was really fat. It was probably like I think I probably wasn't the biggest I'd ever been in my life. Like I was probably a good 40 to 50 pounds heavier than I am now. So yeah, just keep that in mind, please. Be nice. The only reason, like, I hated sharing that video. I was like so proud of it for being on CNN, but I hated sharing it because of how I looked. Now I don't mind it so much because I've lost weight. So now I'm like, oh, look how bad I used to be, But yeah, I will post them. Where can I post them at? I can post them in the about section here, I guess, on YouTube, but I'll put them up on Twitter for now, so if anyone wants to access them quickly. And then I could keep them, whatever, in the about section. I probably should do that anyway. So, yeah, I mean, I always knew I'd be on national news someday. I didn't think it'd be for anything good. So, but all right. I will look for them on Twitter. I'll put them up there within minutes from now. Okay. Thank you, guys. Bye. Have a good day. And I should see you tomorrow, maybe. Bye.